All right, let's get started here. I think we've got most people coming in that that are going to join. Welcome everybody to this intro to the California Consumer Privacy Law, CCPA. My name is Jay Landrum. I'm with Berliner Cohen, and I'm joined by Emily Tewes, who's also an attorney over here at Berliner. We're excited about the opportunity to share some of what's going on with this very new and exciting and ever-changing law that's known as CCPA. So let's kind of get into it, and I'll give you a brief overview of what we're going to be covering today. We're going to cover the basics of the CCPA, which includes things such as what's a covered business. Covered business is one of the businesses required to comply with the CCPA, so we'll talk about that definition. We'll also talk about personal information, what information is protected under the CCPA, and then we'll touch on some of the new rights that consumers are being given by California, and a few of the exclusions that relate to that. Next, we'll go over to compliance. And we'll figure out, first of all, whether your business is the type of business that is required to comply. And then if so, what are the steps that you should be taking in order to start to get compliant? We'll also talk about some penalties for non-compliance. Since we're all living in the land of COVID, we're going to talk a little bit about COVID and steps you might be taking in order to deal with COVID, and how those steps might be interacting with some of the CCPA limitations and requirements. And then finally, before we take any questions, we're going to talk a bit about the future of privacy in California. There's already another privacy initiative on the ballot, and so we're going to see some changes, I think, relatively soon. Yeah. So let's talk about the CCPA Basics. The CCPA is one of the most comprehensive privacy laws in the US. It's modeled after the European Union's GDPR, which is the General Data Protection Regulation, which covers data issues in Europe. And so California has used that as a bit of a model in fashioning their own, the CCPA. The CCPA became effective at the beginning of this year, but the enforcement of it didn't start until July of this year. But now we are in the thick of it, and businesses are required to comply. It's worth noting that many businesses have gone to the Attorney General and asked for some leeway in having to comply based on COVID, and the Attorney General has said no. So, you know, the time is now to begin compliance, and they are not giving any extensions because of COVID. So the law is, at this point, I would say, far from perfect. It's still getting refined, and it's actually going to probably go through even some more changes between now and October. And then once we get those changes, then they'll have a new order of how things are going to be going. So let's talk about CCPA in general. In general, the core of CCPA is protecting the personal information of California residents. That includes both individuals and households. So we define a California protected person as either it's got to be a natural person, so no businesses are protected. Natural person who is either a California resident or living in California, and otherwise, you know, a household. So those include both people who are in California for anything other than a transitory or temporary basis. So even if you're a New York resident but happen to be staying in California for 6 months because of whatever reason, you're still going to be covered under this. And it includes people who are domiciled in California but are not necessarily in California right now. So you're domiciled in California, meaning you're residing here and it's your intention to remain here, but for now you're working a job in New Mexico, you're still going to be covered here under this law. Personal information is what's covered under this law, and personal information is any information that can connect the user or the consumer and the information itself. So whether that's a consumer or a household, if that information can be connected, it's going to fall under CCPA. So personal information includes a lot of obvious things such as your name and your email address and your browsing history and your geolocation, your phone number, but it also includes some things that are, I guess, less obvious, like, for example, how much water does a household consume in a given year? What are your purchasing, what's your purchasing history? And based on your purchasing history, what are your purchasing tendencies? What are your biometrics? I mean, even something as odd as, you know, do you order a lot of products that have a lemon smell, and as a result of that, maybe you're more prone to people marketing products that have that lemon scent. Even those kind of unique features will fall under CCPA. So the only thing that's not covered in this is the information that's either anonymized or it's aggregated in such a way that the information can't be split up in a way to identify who those individuals are behind the information. So, for example, if personal information has been collected where there is a certain area and there are 2 out of 3 people in that area that own dogs, that is not considered personal information. However, if that personal information can be mined down to the level that you can see that Jay Landrum is a dog owner, then that is going to be personal information that falls under the statute. So the $64,000 question here is always going to be, does my business comply, or does my business have to comply? And so to start with, what businesses fall under the CCPA? All of them. You know, you could be a sole proprietor, partnership, a corporation, an LLC, all of those may potentially fall under the CCPA. And so if you are a business, if you're conducting commerce in any way, you are going to need to look and see if you are obligated to comply under CCPA. So as we start to look at that, there are really 3 subsets of businesses that may need to comply. The first is, do you have revenues of over $25 million per year? If the answer is yes, then you are a business that's going to have to comply. One area to note on this is the law here is still a little uncertain as to whether that annual revenue is California revenue or worldwide revenue. There are some indications that it could be one or the other, but for taking it from a conservative basis, you'd want to assume if it's worldwide revenue and you're over 25 million, that you need to seriously look at complying with CCPA. If you are not over that revenue threshold, the next question is, are you collecting personal information from 50,000 California residents or households? So that number it sounds large, but it actually can be very small. If you're collecting data from 137 unique users every day, you're going to break that 50,000 user mark. So you really need to look at your collection and understand, okay, how much are we collecting? The third is whether you're securing a significant amount of your revenue, over half your revenue, from the sale of personal information. And you should recognize that selling is a very broad term in California and under this statute. So if you are, for example, you have a service provider that's providing web hosting and other kinds of services to you, that's fine. That's not going to cause any problems with the CCPA. However, if in exchange for that hosting service, you allow that that company to access your data, which includes this personal information, and you get a discount on your services because you're letting them do that, and they're using that information, even if they're only using it internally to improve their own operations, you've received consideration for that personal information, and the value of that counts as revenue towards your satisfaction with this test. So be very cautious when you start to look at this, and be very generous as to how you're looking at your revenue, how you're looking at your at the consideration you receive on these different aspects. So there are some exclusions in the law that it's not on an industry basis, but you'll find that there are already federal laws that cover certain things, and so the CCPA does not apply there. So, for example, you have hospitals and patient records will be covered by HIPAA, so that's going to be the governing law there, not the CCPA. However, that same hospital may have a set of employees that it collects certain information on, which doesn't fall under HIPAA, in which case that information will become part of the CCPA. So, so you need to be looking and seeing whether there might be some preempting law there, but if there is not, then you need to seriously consider whether it's part of the CCPA. Another group that does not fall subject to the CCPA are businesses that are not in California. So if you're not doing business in California, then you're not obligated to comply with CCPA. However, doing business in California is seen as a very, very low standard. So if you are a business that's doing virtually anything in California, you may fall subject to CCPA. For example, if you have no physical presence in California, that's going to be a game stopper right there. If you have a physical presence in California, you are doing business in California. But even if you just have occasional sales in California, depending on the nature of those sales, even that may be enough to pull you into the jurisdiction of California. So really anything other than just a one-off type of selling activity with California is you're probably doing enough business to satisfy the minimum contacts with California that would require you to then comply with CCPA. Also, nonprofits are not part of the CCPA, so nonprofits do not have to comply with CCPA, at least not yet. Also, government agencies are excluded from the CCPA. So if you're in one of those excluded categories, you're potentially in good shape. However, if you are connected with a company that shares branding, you still may be subject to it. So for example, you're a $5 million company and you don't otherwise fall under any of these other requirements of CCPA, and you may think you're okay, but if you're sharing a brand with a parent company that might be 100 million, then you are most likely going to have to comply with CCPA as well, even though you're a small entity, because of that shared branding. So assuming you fall into one of the categories of the CCPA, the time to start with your compliances is now, because as we mentioned earlier, California has not extended anything because of COVID. Your obligations to comply started July 1, and that's the standard that we're now at. Go ahead, Emily.
The crux of this law ultimately is a consumer protection law. So many of the regulations are built into making sure we're educating consumers about their new rights. So my recommendation is really, even if you're not a covered business under the CCPA, you need to be prepared and ready for responding to consumer requests when they come in. So I'm going to go through some of those new consumer rights that we have under the CCPA. First is the notice right. Think of your privacy policy on your website. That's an instance where you're telling consumers, these are the categories of information that we collect. This is what we do with them, whether or not we sell the information. And your privacy policy is all about transparency. It needs to match your actual practices. Next is the right to know. So individual consumers can now request from your business, hey, I would like to know everything that you collected on me in the last year, and you need to be able to respond to that in a timely manner. With the right to know and this next right, the right to deletion, I think businesses in California need to be prepared for how they deal with potential fraud, right? So what kind of pieces of information do you need that person requesting this information to provide to verify that it really is that person requesting it? The right to deletion is one of those borrowed rights from the GDPR, where now we're saying businesses, consumer can request from their business, I haven't done business with you in X amount of years. I want to be forgotten. Forget me and delete all the information that you have about me. And you need to be able to do that, track that you've done it and prove it, right? There also has to be a right to opt out. So many websites beginning January 1, you probably saw have a very conspicuous do not sell my information button. This is because if you're selling personal information, you have to now give California consumers the opportunity to opt out of that. And if you're not doing that, you don't have to have the do not sell my button on your information website, but I still think that a lot of consumers, as time passes, are going to be asking about it. So if you really aren't selling information, then you need to have an answer for consumers who are requesting to exercise that right. There's also special rights for minors. For 16 to 13, children can opt in, but under 13, it's an absolute no-go. Children cannot opt in. It has to be a parent or guardian. And I would want to take a look at your website to see who you're actually targeting. That's another key part of how your website and privacy policy should be built. So look at your target audience. And finally, there's a right to non-discrimination. So once a California consumer exercises any one of these rights, they can't receive a different price than someone who didn't. So for example, consumer A opts out of selling their personal information. Consumer B doesn't do anything. Both of those California consumers have to be offered the same price for your products. So since employee privacy is near and dear to my heart, one of the really interesting things about the CCPA is, if you really think about it, it's incongruous with so many employment laws that we have. And so in acknowledgement of that, the California legislature did pass AB 25 to amend CCPA, which excludes employee, job applicant, and contractor personal information from most of the CCPA provisions, but it sunsets on January 1. So just in a few short months. But what's not excluded, so if you are a covered business, there are still rights that your employees, applicants, contractors have to have. The notice is the most important one that I would say you need to be focused on. So covered business still has to, at or before the point of collecting the data, notify the consumer. I recommend for employees that this goes into an employee handbook. We'll talk about it a little later, but if you're a business who's really determined to collect health information responding to COVID-19, then I would suggest having a separate employee notice just for COVID-19 purposes, compliant with the CCPA, because the goal is hopefully we won't be using that forever. That's not your policy for all time. And then for job applicants, a separate page that goes with their application. As you're collecting that information from them, you're giving them the notice. And then contractors, kind of a side note, most people are aware that in California, the law has drastically changed, and it is very impossible, very near impossible to have multiple contractors working for your business. So if that's the kind of situation you're in, we should talk on another day. We also have webinars on that topic too, but again, you wouldn't be giving a contractor an employee handbook, so you'd want a separate contractor CCPA notice. There's also security measures that are still not excluded for employees. You have to implement reasonable security measures. I'll give a little horror story. I had a client who, for their HR team, they did background checks on every single employee, except this one time they forgot to do it for one employee. Well, that one employee went into their HR system and took the personal information of many employees, social security numbers, incredibly private information, and attempted to make large purchases on that. I worked with the company, so we made sure that we weren't, that we complied with all the requirements. There are security breach laws that were already in place in California before that they needed to comply with before CCPA. But I'd encourage you to reach out to counsel if something horrible like that happens, and consider what really is reasonable safeguards. As we're digitizing so many personnel records, who has access to that? You really need to lock it down and make sure that it's a need-to-know basis. And then finally on this one, the 2020 November ballot is going to include a new law, if it's passed, that would extend this sunset provision for another 2 years. If not, it's still possible that the legislature might extend it because, as I said, I think it's pretty hard to see the CCPA and so many of our employment laws in California reading together, and the requirements that you keep information on your employees, very sensitive information. And then penalties for non-compliance. If you weren't just already inspired to jump into CCPA compliance, you should know that the Attorney General is taking this law incredibly seriously. July 1st, they began enforcement efforts, but there's also civil penalties up to $2,500 per violation, $7,500 per intentional violation. And consumers themselves can go after, recover statutory damages between $100 to $750 per incident, or actual damages, whichever is greater. So I think that little clause there is going to be a big issue for when there's actual damages of identity theft and fraud, things like that. And then in practical penalties, if you get a non-compliance letter from the Attorney General's office, you should reach out to counsel, you should respond, you should engage with the Attorney General. You have 30 days to come into compliance, and showing good faith effort that you're making progress is better than digging your head in the sand, right? This could open you up to a full-scale investigation from the Attorney General's office. They can have access to your entire business operations, and they're no longer limited to the CCPA as their investigatory scope. And then also just be aware that plaintiffs' attorneys are looking for CCPA targets, and when you're subject to one of those public full-scale investigations, there's a risk of a class action suit. We've already seen about 15 to 20 class actions filed referencing the CCPA before it was even enforceable. So there really is a high likelihood that this is going to be a new class action law that's used in California.
So let's start from the premise that, from what you've heard now, you know, we agree that you need to comply with this law. What's the first step we need to go through in order to start compliance? The first step has to be getting your arms around your data, conducting an audit of your data, and building what's called a data map. The data map is something that connects data fields from one source with other sources. It's a way of being able to look at all of your data and know essentially what's being collected, how is it being collected, where is it being collected, where is it being stored, how is it being stored, where is it being used, who's being who's being sent that data, you know, who's receiving that data, whether that data can be batched in some way. So for example, is your data organized in a certain way where you could say, we're taking all California residents, consumers, and households, and we're putting them in a separate area for that data so that we've segregated that data. Are you able to do that? So it's really getting your hands around that data and identifying your records and your sources of those records. And at that point, you now have that data, and now you can really start to figure out how you manage it. So obviously, the more you can link that data together, the better you'll be able to manage it. especially in cases where, as Emily mentioned, if there's a right of deletion, you want to be able to go and delete that consumer in one spot and have it delete everywhere, not have to go through all these different bits of data and try to mine out everywhere where that happens. If you're a business that's already started to go through some of this data mapping because of GDPR, keep in mind that the CCPA, by adding this household requirement, that has added another layer there where data mapping for the GDPR may not sufficiently cover it. So even if you've got your data mapping done for GDPR, you may have to take another look at it for CCPA and the requirements specifically around household. But now that you've got your hands around your data, the next thing to do is really to review your policies. Because as we mentioned before, the CCPA is focused on the collection, use, and disclosure of that personal information. And so now you need to look and say, okay, what are we doing with this data? And it may be that you have to, oops, hold on. It may be that you need to update your privacy notice as a result of the CCPA. Emily mentioned you might need to be adding a "Do not sell my information," my personal information button on your website. You might create retention policies. You'll need to create deletion policies. You'll need to figure out a process for handling consumer requests, and not only handling consumer requests, but rejecting consumer requests. Just as you need to provide information to consumers, you also need to be sure you're not providing that information to people who are not really that consumer. And so these false consumers, so companies are now creating a procedure that essentially validates who that consumer is before they fulfill that consumer's request. And so you want to take reasonable measures to make sure that you're making sure that you're giving that data to the legit person. And with all of this swirling around, if you're sitting here thinking, gosh, how are we going to get all this done? Many companies have now leaned towards appointing a data officer, someone who's really tasked with managing this data and setting policies and enforcing policies and dealing with consumer requests and being kind of the leader on this particular project because it is a lot of work, or it can be a lot of work. Once you've gone through that whole review, the last step is really making sure that we're getting the employees educated. We obviously don't want them mishandling or misusing the data or providing them to the wrong consumers, false consumers. But we also want to educate them and train them on how to honor those legitimate consumer requests. Also, by getting the employees well trained, they'll be able to flag the company on any kinds of issues that might be coming out of that privacy, that data that relate to privacy, so that you can make sure that you've got all that covered. Just wanted to touch briefly on the idea of where this law stands. So the Attorney General has released its third and final set of proposed regulations to something called the California Office of Administrative Law. And that Office of Administrative Law is tasked with the responsibility of looking at those regulations and embedding them for compliance, legal compliance. They have 90 days to do that. The most recent proposed regulations were submitted on June 1st, which means assuming that the government will take what the government takes most of the time, we probably won't see any changes until October 1 or so. So it's possible that OAL will come back and say that these regulations need to be tweaked in this way or that way, and so October 1 will we'll need to review what we've got and what's changed. In the meantime, as Emily's mentioned, and I've mentioned, the enforcement of the CCPA has started, and so we can't ignore that. The cost of compliance is estimated. It's a very broad estimate. You see there that that the Attorney General's office has estimated it's somewhere between $500 million and $16 billion or so. But it's a broad range. But I think everyone who is trying to get a hold of their data and understand how to comply with CCPA is not looking at this and thinking this is a simple undertaking. So the other thing to recognize about the Attorney General's office is it's really here for the enforcement of the CCPA. And in this case, consumers have a relatively narrow set of rights for enforcing generally around data breach, but for just general misconduct and failure to abide by the CCPA, that's the Attorney General's realm. So they are the one that is getting prepared to go off and deal with compliance.
As we know, every county seems to be doing its own version of how can we respond to COVID-19. California has also had, the governor has made many orders, and we're all trying to comply. It seems like the rules are changing every day, but there's important part to think about the CCPA and your business's COVID-19 response. So the example that we get a lot of questions on for businesses are temperature checks. So you're taking the temperatures of everyone who comes into your business, of your employees, right? And I think I looked it up this morning, it was 100.4 is the cutoff that the CDC is saying right now. But I would really encourage every business, whether you're CCPA covered or not, to think about weighing the risks and rewards of collecting that data and recording it. It's different to take the temperature than to commit it to a piece of paper. Because as we're talking about the CCPA, I don't know if we've made it clear or not, but this isn't limited to digital data. This is the hard copy personnel file. It's every piece of data, your old-fashioned Rolodex, all of that. Those are pieces of personal information that you have recorded and are using. So in temperature checks, I just want to really reiterate, once you take that temperature check, you're creating a sensitive health record, which has to be kept completely separate from a personnel record. Again, businesses have to provide notice prior to collection. So if you are a business that really wants to go down this path of recording temperature checks, you need to provide that separate CCPA notice for your employees that's specifically talking about COVID-19. That's my recommendation, is it's a specific COVID-19 notice, because hopefully we're not using it forever. And the employee exemption, remember, it sunsets on January 1st. So technically, you're collecting data now that could be setting you up for a whole host of regulatory issues in the future. And then also vast amount of data. You know, if you're collecting the temperatures of every employee every day that they come into work, pretty quickly that's going to really turn into a huge amount of paperwork that's maybe not necessary. You know, and then also liability, like I mentioned, the temperature cutoff on CDC says 100.4. What happens if the employer chooses 100.3, but the county said 100.2? You're just getting into semantics that maybe you don't need to get into. It's as simple as you took a temperature check. Did it pass the standard that you determined based off the CDC that day? Great, then they come in. You don't have to record that somewhere. You could also do maybe a checkbox, a yes, no. Did they pass all the self-screening requirements? And then also what's happening often is notifying employees about the risk of COVID-19 without divulging confidential health information. You can't tell an employee, hey, you worked with Bob yesterday and Bob has COVID-19. He just tested positive. You need to know. It has to be much more nuanced than that. And there are restrictions about which employees you tell based on who had the most interaction. And it's, again, changing county by county. So I do recommend that you reach out to Employment Counsel, you reach out and you call us if you're having one of those instances. And it also changes based on industry. And then finally, the tracking technologies and self-assessment apps. In many other countries, they have not had a difficult time of implementing these what we in the United States would consider incredibly intrusive technologies into where have you been, taking scanner codes with your cell phone so they can track where all the places that you might have been exposed to COVID-19 or that you might have exposed others. Sonoma County, for example, tried its own version of this. It did an employee mobile app for self-screening. Initially, it was rolled out as a requirement. After a lot of concern, they immediately changed it to an encouragement. It's no longer a requirement, but the piece of that was an employee who's working in an essential function needed to complete the self-screening in an app that goes to the county. Then the employer had to respond for every employee who had submitted their information through this app and verify that they too had done these screenings on that employee and could verify it. So if you're in one of those counties where they're rolling out these kinds of new apps or technologies, it sounds like a great thing, but I do recommend having a conversation with counsel and seeing if this really is a requirement. Should your business be doing it? What's your industry like? There's all kinds of important factors to consider. And then, as Jay has alluded to, the future of privacy in California seems to be here, and it's ever evolving and changing. We have a new California Rights Act on the November 2020 ballot, brought to you by the same folks who brought you the CCPA. This one is called the California Privacy Rights Act, and there are a few important things that I want to go through. Its impact on small business, it could be helping small businesses because it's going to narrow that second prong of who is a covered business from collecting 50,000 consumers to now you need to collect data on 100,000 consumers. There's also a voluntary certification similar to, this slide is already a little past date because it's similar to what was compliant under the GDPR, no longer. Thanks to a Schrems II decision, Europe's High Court has decided that the US can no longer self-certify that they comply with Europe's GDPR laws. And back onto our California Privacy Rights Act, it's going to add a new category for sensitive personal information. There's going to be a purpose limitation, which is already a good practice when you're building your privacy policy. Are you collecting data that you have an exact business purpose for? If there's no reason for me to collect your middle name, why am I doing it? Think things like that. You should be building that into your practices. It also is going to add a new consumer right to correction, which makes sense. If I've requested my information from the business and they've told me and they spelled my name wrong or that's not my address, whatever it is, now I can submit under this new law. If it passes, I would be able to submit a right to correction to have that company have my correct information. It would also expand that deletion right to all the third parties that you shared it with. So once your company gets the deletion request, you can confirm that you deleted your data. You now have to tell all the third parties you shared it with, you sold it with, you shared it with, think your vendors. There's going to be a lot more business interplay where you need to have contracts to make sure that they are also complying with this right to deletion, even if they aren't a CCPA covered business by virtue of doing business with you. Now they do on this. It also would extend that employee personnel exception for another couple years, which would be great. But it creates a new enforcement agency, the California Privacy Protection Agency, and it would create a regulatory landscape similar to the EU and increase resources for privacy-related investigations and actions. And I don't want you to leave thinking that the Attorney General isn't completely staffed up for the CCPA. They are. They have all the privacy experts there who wrote those lengthy, but I think very good regulations. It really explains a lot of those missing pieces that were in the CCPA. So I would suspect that even if this new law passes, maybe the staff from the AG's office moves over to this new agency.
Okay, so before we take a couple of questions, just a summary of Emily and I and our backgrounds. We're both in the privacy group over at Berliner. I'm in the corporate and tax group. I work with a lot of corporate law issues, M&A, and IP issues. Emily is over in our employment law group. She works with a lot of businesses as well, and is closer to the employer-employee issues than certainly I am. So both of us are available to talk further. If you're looking, our emails and phone numbers are at the top there, and you can also find us on the Berliner website. So I think we have time for maybe one or two questions.
Okay.
Emily, you.
Yeah, let me look for a good one. Okay. So here's a question. Our website has a privacy policy. I don't think it's been updated in a few years, but I spent money on a lawyer to get it right when we did write it. Do we need to update our privacy policy in light of the CCPA?
Yes, is going to be the answer to that. The CCPA has added a number of other requirements and disclosures that are going to be important in your privacy policy, and so you're definitely going to want to revisit your privacy policies and make sure that they are in sync with the CCPA.
Absolutely. Yeah, and I would also say that if you are a CCPA compliant business, there's a lot of new things that need to be in your privacy policy, but the theme really of the CCPA is transparency. So it's probably pretty likely that you've changed vendors or you've changed business practices in the last couple of years too. So that would be needed to be reflected in your privacy policy. Okay, here's another one. This all seems kind of overwhelming. Bottom line, what do I need to do to keep the Attorney General away from my business?
Well, the first thing to do is, and I agree, it can be overwhelming, no question about it. But the first thing you need to do is really to get your hands around your data. You know, how, as we talked about, the data mapping, knowing where you're collecting data, how you're collecting it, where you're storing it, how it's getting distributed. All those are critical issues. I mean, it's really impossible to start to address the issues of CCPA and the requirements of CCPA without really understanding your data. So understanding your data is job number one. And I think once you do that, you'll have a more clear path on what needs to be done to get compliant. And depending on what shape your data is in and how it's housed and so on, it may be it may not be that onerous a task, or it may, if your data is kind of scattered in a lot of different places. So first step is getting control of your data, understanding what it is.
Okay. What does the employee notice require? Should I be doing that right now? I'll take this one. If you're a covered business under the CCPA, then yes, absolutely. The Attorney General regulations give very great guidance on what needs to be in that notice specifically, but it's really only something that you can do after you've done your data auditing. And employee data should absolutely be included in your data map. You're looking at every single piece of information, even employees, contractors, applicants. My recommendation is I like to see it in an employee handbook. It does seem a little retroactive because for most current employees, you would have collected the bulk of their personal information a long time ago. You would have collected bank routing information so that you can do direct deposit on their pay stubs. Within the first couple months of employment, they would have probably gotten that done if that's something that you're keeping. But I recommend, I like to see it in an employee handbook. And then again, if you're going to be doing intensive COVID-19 response where you really want that documentation, a separate policy for that. Separate policy for applicants, just a 1-page that goes right in front of their application. And then again, for contractors, you're not giving them that employee handbook, so you want to make sure they have something separate that goes with their contractor packet. Yeah, so it is a requirement now. It's always a good time to review your employee handbook and put that in. There's plenty that we can do there.
Great. So just a little bit about Berliner. We're a full-service law firm. We've been around for 50 years, San Jose based. We have, as we mentioned, the corporate and the employment law groups, but we also have people that work in IP and estate planning and real estate and a number of different practice areas. So please reach out to us with any questions you have about this or anything else going on in your business. And we really appreciate everybody's attendance today. And by all means, reach out to us and give us some feedback on today's presentation.
Thank you very much.
Thanks so much.
All right, bye.